I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go.
Welcome. Today we are going to talk about Shanda Vander request for a new trial. The details of her original trial are extremely horrific. I will not be going into I won't be going into the specifics of the case. Some of it will come up in the testimony of her original lawyer. So she is currently appealing her conviction, and the jury convicted her of first degree capital M. Okay. Red drum, however, because that's the word backwards, or no, I think it's red rum. Is it red rum? I say redrum. So we laugh here just to keep from crying all the time, because these cases are extremely, extremely traumatic. And once again, she is the perfect example of how one child can be targeted as the problem and because this resulted in her child's death, this maltreatment. It was absolutely horrific. Her lawyer thinks there's something wrong with her, and she was evaluated by multiple people who all just said it's based on his testimony that she's a monster. That is that's what he said. I didn't say that. That's what he said. I have some prior coverage of her case, which I have my very first video. I also covered Paul. So Paul Ferguson was one of her surviving sons. He testified because he was involved with the treatment of Timothy. Timothy is the son, 15 years old when he passed. And it was extremely horrific. And they're trying to be like, the cause of death might have been something related to dehydration, but he weighed, let me look that up. Let me see. How much did Timothy Ferguson weigh? Oh, 69 pounds. Okay. So how can we be focusing on water? And he weighed 68. When I Googled it, it said 70, said 60, when he weighed 68, 69 pounds. How can we be talking about dehydration? But that's what the appeals attorney is, just doing what appeals attorneys do. Okay. But we normally don't get a look into the ins and outs of the appeal. And so she was granted a hearing. And so I'm not laughing because it's funny. I'm laughing because it's Shanda. Shanda likes to pull a lot of stunts, and she's going to claim that she was too sick. I don't know what was going on with her, so I can't say whether she was sick or not. But we're going to move it back. I have some notes. All right, let me know if y'all have questions as we go. I prepared with some specific. I have my timestamps and now I can't find them. I know, what in the world? I have my little background person. I found them. So my kid figured out what redrum backward was. Yes. So he will be hanging out with us in the background. All right. Yes. So her first attorney, his name is Fred Johnson. Yes. And 2224. All right. All righty. And so this is Shanda with her current attorney. We will see what happens with this. So she waived confidentiality to allow her lawyer to speak about these things. So Fred Johnson, his law license was suspended for 6 months due to a confidentiality issue with a completely separate case that happened years ago. He served, so the 6-month sentence or the 6-month suspension is already over. He chose to take an ethics course. It sounds like his office was just really big and there were records he shouldn't have had access to that he did see, and he used it because I guess there were 2 client files. His office was handling 2 separate cases, and he shouldn't have had access to one of the files because it was the victim of the defendant, the person he was defending. And he used that victim's medical or mental health records, one of those 2. He used those records to defend his client, and that was deemed unethical by his board, and he received a 6-month suspension for that. Okay, so that did come up during this hearing. Shanda's current lawyer talks about the fact that she never admitted to any guilt. But the way it's phrased is that she won't admit that she did anything wrong. So she does not think that she did anything wrong. But I think that's her weird like justification. I think it's that Sarah Boone, we all can see what she did and she won't admit it. Like it doesn't seem like it's not. Yes, and that case was before this one, but it did come up. So Shanda's attorney did bring up the fact that his law license was suspended for a completely separate case, and the judge is going to ask him questions. We are going to watch that portion as well. We are not going to watch this entire hearing. So I do have a link to the full court TV video, so you can take a look at all of it. So I've highlighted specific parts for us to talk about. So right around here, they are going to talk about how they obtained an expert, but chose not to use the report of that expert. So let's go ahead and start here.
Did you have Ms. Vander see a professional with regard to competency or criminal responsibility?
I had Ms. Vander see several professionals, 2 doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversations we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I personally think that statement, so that she does not personally think that she did anything wrong, that's more of the she's not accepting the details of what happened, because we are going to watch the part where he talks about that there is a video. There is a video that is so bad that they were able to just stipulate to the facts of the video, and the actual video did not get entered. So I think there's a Sarah. So I like to compare things to Sarah Boone sometimes. She's the case that, I don't know, because that George in the suitcase video, like that is stuck with me forever. There is a video that we have not seen for that, and I do not. So if there was anybody that ever put it out there, I would never, ever say it. And so the fact that she just doesn't think it was her fault, but that doesn't mean that she wasn't responsible, because there are messages where she is, I think Paul, the older son, sent her a picture like, should I give him food? And she said no. So like, and that's the statement that Fred Johnson, the attorney for the trial, her trial attorney, he's going to say that was when he decided to shift to more of a manslaughter thing. okay, to like, okay, like let's at least try to get it down from first degree. And he even said in this, maybe she might have got second degree. Like he was hoping for maybe manslaughter or second degree.
I don't recall that specifically. If you have the report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, as what I recall.
May I approach the witness? You may.
Here. Yes, sir.
And it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial as she was charged with first-degree murder. But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
And once again, so there is a clinical delusional that's psychotic, and then there's I just don't want to accept the facts of what happened. So there is a big difference. I personally, so I haven't evaluated her, and she's never been diagnosed with any type of psychosis. Um, uh, so Shanda wouldn't have admitted that she had multiple personalities. So Dr. Lewis only does multiple personalities. I don't think Shanda would have, because she wants to be seen as competent. She could have been a lawyer. Could you imagine if she had been like a practicing lawyer? Like she had all the credentials. I think Fred is going to mention she might have missed one question on the bar exam or something. I don't know. Like Fred is going to praise her accomplishments a little bit later. I don't know that we're going to watch that part, but.
Were there any offers made to Ms. Vander?
None that I can recall, Your Honor. Sir.
Okay. So this Shanda Vander is requesting a new trial, and she's saying ineffective assistance of counsel. So Fred Johnson is on, so he was called by the defense. So Shanda's, or I don't know how, they're in the appeal process. So the defendant's lawyer, the appeals attorney, called him to ask him questions. Okay? That's where we are.
Now, Ms. Vander testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That is correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son.
I believe that was if we're talking about the situation where she turned and there was a trash can there and she appeared to I don't know if she actually did vomit, but she had, the body language was indicating that's what was going on. I was sitting in the chair over there where the prosecutor is.
And during her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And
Cross-examination was aggressive and effective. So the state did not hold back. The state went after her. And I'm agreeing with you. I don't think she would get a different with a whole new jury. The details of this case are horrific. Now, I don't know if Paul would. So Paul is her son that testified. And this was before he had his deal with the state. I'm wondering if she's thinking Paul might change some of his testimony. I don't know what she's thinking if she got a new trial. I don't know what she thinks would be different.
Did you see Miss Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her?
All right. So I am going to skip ahead because the state is going to cross-examine. So the state is going to ask him questions and they're going to go back to that whole expert thing. I will mention that Fred Johnson mentions that after her testimony that she was in what he said he told the media. He's going to repeatedly say, I told the media she was in a catatonic state. But the state is going to call one of the social workers. So this is a really cool public defender's office. They have social workers that meet with the defendant that are present during the evaluation sometimes. So the social worker who is trained to know what a catatonic state actually looks like, she's going to say, no, she wasn't. Looked like she was having a panic attack. Like it looked medical, but I don't think she was incompetent because Shanda's defense is trying to say that like court should have been delayed because she did not return for the verdict to be read or for closing arguments. I think like after her testimony, she did not return to court. Okay. So once she finished testifying, she was not in the courtroom for closing arguments. And I don't think she was in the courtroom for sentencing. I could be wrong. She might have been there for sentencing. Y'all know sometimes I get details wrong. You can argue about it in the chat. No, please don't. It's fine. Do you. I'm going to skip ahead to the state's cross at 241:49. 241. There we go.
From the other lawyers in the office, have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
The experts.
Okay. And so I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes.
Okay, and to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients. They would have been prosecution witnesses had we presented their findings.
So you intentionally did not call these experts?
That is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, she's a monster. His response was, she's the worst thing he'd ever seen.
And this man has worked with people that have had multiple homicides, like that have completed multiple ones. I love his phrasing, uniformly and enthusiastically. Like, it's just like, Shanda, what did you want? Like, none of all the doctors, I'm guessing they probably could smell the narcissism and OCD personality traits. I don't know that that's her diagnosis, okay? So her formal diagnosis has not been given. But they were like, "No, she's a monster." Like, she knew exactly what, like, she just doesn't think it was wrong. Eh, And Mr. Johnson still thinks that there's something, because I think he wants to live in a world where people like her don't exist. Do you know what I mean? Or we can explain it that there's maybe she was psychotic, or like maybe there was something else going. Like, I think he wants to live in a world where people don't do this to their own children. That's the world that he wants to live in. But his client, all the mental health professionals, it sounds like there were at least 4 that assessed her. They all said, but he's trying to base it on the fact that when she met with him, she was compliant. She never argued. When she met with him, she was a good person. 2 things can be true at the same time. She can be nice to him and horrific to her son. And it's my understanding she had a history of child harm, and that's why she was not supposed to have unsupervised contact with these children. She wasn't, and I don't know that that fully came into court. I don't know if it did or not. I don't know. But a new trial will not help this. It will not help. Once I heard this part, I was like, okay, we definitely have to watch this and talk about it.
And he's a man who testified for mass murders. I did not want to bring his testimony in. Dr. King simply said that she was competent at the time, and she was competent for trial, and and that's not what I wanted the jury to hear. I want the jury to hear that there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for him. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. It probably is just because that's the way I'm built. I just can't believe that a healthy person would have done the things that she did. I don't believe it to this day.
So I like Mr. Johnson. I think he did the best he could with some bad facts. The jury, and there's somebody on the jury. There's one juror that held back for first degree for a little while because Fred Johnson pleaded, like he was trying to get them to manslaughter. Like, she just didn't realize. She just didn't know. Like, she didn't intend for this. Like, so he was trying to get the jury down. And so there was one juror that it took some convincing to get them, but they eventually did get to first degree unanimously. And the state wants to use that as a reason that, like, his defense was actually effective. And she's not gonna get a different result with a different, but like, I don't, it's a legal thing, and y'all know I'm not a lawyer. So if I ever have a lawyer back, or if any other lawyers cover this, I will definitely watch it, because she's trying to say that she did not agree for him to say manslaughter in the closing argument. So prior to this, she did not talk to him, and it did not come up that day that he was going to admit, or that he was going to try to get the jury to do anything other than not guilty. So she only wanted not guilty. That's what she's saying now. And he's going to say, during the state, he's going to say that they talked about all the different things and that they talked about this could be an option. And that's what they're going to say.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in
Yes.
fact, do that?
Yes, ma'am. The evidence? Yes.
And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation?
Of my client?
Of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she's going to testify in this.
So this is a great question. And it's like, so do you think Shanda thought she was a legal expert and could figure a way out of this? So Fred is going to say that he viewed her almost like another counselor, like a counselor on his team, because she understands the law. She understood the perspective. She understands the different things. Now, could the judge rule that she gets a new trial? Because it does sound like Fred decided for the closing argument that it was his strategy to say manslaughter, and she's in the holding cell having this medical emergency. I don't know, that she's going to say she did not agree to that. I don't know. But was she trying to do something for appeal? Like that's the part where my brain is just like, I don't know about this. Was she did she intentionally not be present for prior to closing arguments? Because if he did something that she didn't agree with, she could later say he didn't consult with me. He should have requested an extension. Donna, I agree. And the judge overseeing this part of it is the trial judge. So this is the judge that oversaw the actual trial. All right. So let's keep this going a little bit longer.
Sorts of things she might be asked and sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions
Yes.
on this case?
Certainly. And that was the value of the groupthink. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take it to the Court of Appeals? We lose that sort of thing. All those issues were discussed.
Did you also prepare for your voir dire in this case?
Yes, I did.
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes.
Okay. And in preparation,
I'm going to skip over the allegation that he did not prepare for voir dire. We're going to skip ahead. The judge, wait a minute, let's see, 3/11/06. So it's my understanding the video, they're going to talk about the video that did not come in. Okay. So let's go right about here. They're going to talk about the video. So there's a video that we have not seen.
Parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration, or she injured him by starving him, or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
okay. So that was a conscientious choice on your part.
Sure, and we weren't arguing that the boy was dehydrated. We weren't arguing that he had passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
So I think in her attorney, so I think her appeals attorney is saying ineffective ineffective assistance of counsel because Fred Johnson did not argue dehydration, which is ridiculous. Like, Timothy died in a bathtub. Like, I'm sorry. I know my kid overheard that.
I think I would have lost the jury on that. They had photographs of this boy. And nobody's going to take a look at those pictures and say, this boy needed water.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The
Okay.
best thing I did in that trial was the best thing that happened in that trial was the fact that video didn't come in. That video is literally the worst thing I've ever seen.
Ever.
There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our clients than showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I die, that was the right strategy. It's the best thing we did during trial was keeping that video out.
He emphatically. So I don't know what's on that video. And I'm not going to go back and watch the whole trial. So I guess there was commentary introduced about this video, and oh my gosh. Welcome. I hope everybody had a good holiday. Do you think Shanda was protecting all of her frustration and anger? Was projecting all of her frustration and anger onto her son. So I think she had this unrealistic expectation, and he also had autism. So we know Timothy had autism, and I think he wasn't doing, because I think she valued performance, and I think she might have thought he made her look bad. I don't know. And if he was in school, because she pulled him out of school, I believe, because if he was attending school, people would have known. They would have called CPS on her, and she had a history of having CPS called on her in the past, and so I think, and just my thoughts in general, because I don't know her exact situation, my thoughts in general are individuals like her tend to go overboard with discipline, where I think Timothy was like the scapegoat, and he could do he couldn't do anything right, because the things she would complain about seemed like typical things. And then also, I think he had ADHD and was on the autism spectrum. And so I think she was expecting too much. Individuals on the spectrum and individuals with ADHD, sadly, can be harmed by caregivers at a higher rate, because sometimes they do have behavior issues. Sometimes they do have outbursts or tantrums, and people can, if they don't have the skills to manage it, they can go overboard. Those are just my general thoughts on what could have been happening here. And then also, I think she's just a sadistic, mean, like, ugh, like. And then I think she liked that Paul, because I think she would have said it was Paul that did it, because she would have Paul do the harm. She would have him do it. So I think she was always going to say it wasn't me. It was just Paul's evil. It wasn't me. And it was her. And that's what the jury found.
It's just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution, and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers
My position was that the video was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close on. It's just it was. And given the weight of all the other information that Mr. Roberts had presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it.
All right. So let's skip ahead to the judge's questions. So they took a lunch break, I think, and then I think they had some other people, because I think they had a deputy, or maybe they just took lunch and then he came back. I'm not going to go over the deputy's testimony. It's like 427. Okay. So the judge is going to ask Mr. Johnson questions.
People versus Shanda, Vander. Where we left off, Mr. Johnson was on the stand. I think the parties had concluded their questions. The court did have some questions for Mr. Johnson. Mr. Johnson, you obviously know you're still under oath.
I do.
All right. Let me just see here. There were some questions about by Mr. Ambrose regarding the suspension.
Yes, sir.
That I think occurred, last year or this year?
I served it last year. It took almost 9 months to get the process rolling, so it actually occurred the year before.
All right. And my understanding, and you've actually been here and a Gither hearing for that case, correct?
For that case, yes, but
court.
Not for that issue.
You're not for that issue, but in this court, correct?
Yes, sir.
In this very courtroom, correct?
That is correct.
Okay, and that was for it was People versus LTJ Udall, is that correct?
Yes, sir.
And that was 2019, I think it's 947 FC?
Yes, sir.
All right. And I just want to, for the record, my understanding is the basis of the disciplinary action was that in that case, let me just go back. My understanding of the facts of that case, very briefly, Mr. Udall was charged with criminal sexual conduct, I think in the first degree. Is that correct?
Yes.
Okay. And the victim of that charge was a client or represented by the public defender's office. Is that correct?
Yes.
And that was in an abuse neglect case or an NA case, correct?
Yes.
All right. In my understanding, you did not actually handle that case, correct?
That is correct.
And was it other members of your office that had handled that?
Yes.
All right. And my understanding is there was a file that was taken from your office detailing this minor child's counseling records, psychological records. Is that correct?
Yes.
And my understanding is that you actually used those in Mr. Udall's defense.
I saw them. They weren't used.
They weren't used, but you certainly used them to prepare.
Yeah, yes, sir. I read them and I knew.
And my understanding is there was supposed to be, you were supposed to isolate yourself from that. You was set up to isolate yourself from those files because you knew there could be a potential conflict. Is that correct?
Yes, sir. We had processes in place to make sure that didn't happen.
Okay. And that did not happen.
That's correct. The processes failed.
And so essentially you actually used what were supposed to be withheld from you.
Yes.
In that case, Mr. Udall's case, is that
Yes,
correct?
sir.
And that was the basis for the judiciary or the complaint,
Yes, sir.
grievance, correct?
Yes, sir, it was.
And you admitted that this happened, and I don't think you contested it at all, correct?
That is correct.
All right. And that's the basis for the disciplinary action, as far as you know.
Yes, sir.
All right. As far as you know, did the disciplinary action have anything to do with, not getting back to your client or not talking to her, doing something that you weren't supposed to do in terms of representation, something similar to what's being alleged in this case?
No, sir.
All right. My understanding is that there was Mr. Udall's case actually had 2 trials. Is that correct?
Yes, sir.
All right. And you represented Mr. Udall in the first trial. Is that correct?
Yes.
And what was the result of that trial?
I was a hung jury judge.
Okay. And then the second trial, I have, at least according to what the records say, is they occurred in December 13th to December 15th of 2023. Is that your recollection?
Yes, sir.
Okay. Now, you had testified. Mr. Ambrose had asked you about, your stress level at that time. You were on a conveyor belt.
Mm-hmm.
I'm just So I want to clarify here, because when he was initially talking about his law license getting suspended for those 6 months, he mentioned that he was under a lot of stress. There were a lot of cases and life felt like a conveyor belt. And I think here he might mention he didn't take vacations, he wasn't taking care of himself. But when he received a high profile case, or like a major case, he would make sure that that case got his full attention. Okay.
Was that true at the time of the second trial in Mr. Udell's case? That you were on a conveyor belt? I think that's one of the reasons you said what was going on for the disciplinary action. Is that true?
Judge, it was. That the workload continued unabated for the time I was at the public defender's office. It was self-inflicted. I didn't go on vacations. I didn't, when I retired, I had 50 more days of vacation time that they didn't even compensate me for. I was at that office and I was doing that work. So yes, it was a continuation of the same process throughout the entire time. The only difference being was when it came to a capital, well, it's not capital in Michigan, but a life case in Michigan, the priority shifted so that the time that I needed for that case would shift to that big case, the life case, as opposed to misdemeanor cases that I might be working on.
And I actually misspoke. So my understanding, I got this trial, Ms. Vander case actually took place between December 13th and December 15th of 2023. Is that your understanding?
Yes, sir.
I had it wrong. That Udell case happened in April of 2022. Is that your recollection?
I thought so. I thought his was done by the time Ms. Vander Ark began.
Okay. So this trial,
Yeah.
did you go right from the Udell case to focusing on Ms. Vander Ark's case? Because it looks like they went from April 2022 and then a little over a year later, you're trying another FC case.
No, I think there were at least a few weeks in between. I don't think so.
All right. Now, was there, looking back on it,
Yes, sir.
were you able to give Ms. Vander Ark's case what you felt was the appropriate amount of attention for an FC case?
Yes, sir.
Okay. Was that with the assistance of the people you've already indicated?
Yes, the team did.
It wasn't all you, it was the team.
That's correct.
All right. And would you say that you were in charge of the team? Like,
Yes, sir.
you weren't absent and said, look, you guys do all the work, I got to take care of everything else? Or were you there for meetings? Were you there for other stuff?
I was there.
Okay, all right. And I'm trying to understand the defense strategy, okay?
Yes, sir.
From what you've testified to, my understanding is that your strategy was to essentially go from a intentional crime to a negligent crime. Is that correct?
In effect, yes, a crime where there wasn't the mens rea to commit harm. So yes, sir.
At the break, I looked up the jury instructions, and it looks like you, correct me if I'm wrong, I can't remember exactly, but did you ask for the involuntary manslaughter instruction?
We did not.
You did not?
No, sir.
Okay. But it was included, correct?
Yes, sir.
All right. Was that at the request of the prosecution, do you recall?
Now that you mention it, I don't remember who asked for it. Now that you mention it, I don't know, because we obviously, for the record, we discuss these instructions in chambers, and the instruction, it would have come up. I don't know who asked for it. It might have been me. I don't remember.
Okay. So my question is this: you had testified at the beginning of Mr. Ambrose's questioning that Ms. Vander Ark had not given you consent to ask the jury for a manslaughter verdict.
That's correct.
Was that
Okay. So I skipped this part of it where so he did not get her consent to include this. And I think the state is going to clarify that. I think with a first degree, I think they automatically include some of the lesser include. I don't know, but they're going to talk about this, because this, I think they're trying to figure out, did he do something without his client's consent? That's the legal side of it that y'all know. I'm just watching along with you all.
your testimony?
Yes, sir.
But then later on, you said the focus was going to be this is not an intentional crime, that there's just something wrong with it, correct?
Yes, sir.
My question to you is, when these discussions between you and Miss Vander, did she unequivocally say, I am not guilty of any crime? Or was the discussions, look, I didn't do this intentionally, I didn't mean to do this, I'm not going to plead to something that I didn't intentionally do? Was there a dichotomy in that discussion?
The discussions about her responsibility came in two phases. The first phase, when we first met, she told me the same thing she told the police at the time that the boy was discovered, that she found him in the bunk bed, she poured him down, and she's trying to administer CPR, and et cetera, et cetera. That's the first thing she told me. Then after that, once we got past that and the police reports came in, it was clear that wasn't the situation. We talked about individual defenses to individual crimes. And we covered everything. We covered all the things that she might be, that her conduct might find, the jury might find her guilty of. I never directly challenged her, did you do something here? And that's not my way. If a client either wants to talk to you about that way or they don't want to. But based on the conduct of our conversations, it was clear that she was aware that
I'm taking a deep breath because it's hard to watch her shake her head and watch this part. I agree with you, Donna. The only thing I don't like is that this judge lets her shake her head. Yeah. And I think because the jury isn't there, so I think the judge is just allowing it because the jury isn't there. Sometimes if the jury is there, I think they're more aware of what the defendant does. She definitely looks like she's gained some weight and she looks a lot older. But prison will like age you. Remember she did the pigtails for court? The pigtails. Ugh. She looks a lot older. I don't know if she dyed her hair before, because it definitely looks grayer, but yeah, it is what it is. Yeah. Yep. All right, let's keep it going.
there's something that's wrong here. There's something that I may be found guilty of. And that's kind of how we kind of, in order to bridge the gap from her having to confess to me, we kind of discuss it as there's something you might be found guilty of. And this is the things you might be found guilty of. And this is the things that we might be able to achieve if we do these sorts of things. And avoiding, and the bottom line is avoid first-degree murder.
So it was never, she never said, well, I'm guilty of something. It was more of discussion about, okay, throw it all out the window. What could the jury potentially find? And what's a mitigating thing we can do? Is that right? That
was the strategy, Judge. It was never, I never confronted her to ask her if she did something wrong or not. I gave her the way out. The jury might find you guilty of these things. What are we talking about? And that's how we bridge that gap.
So there was never an affirmation on her part that I recognize that I am guilty of a not unintentional type of charge.
Never before or since.
Okay.
So I went back to edit the description because I didn't have all of my prior coverage. So I remember in her sentencing, she had them correct her degrees. Like she had them correct the smallest things. And that's what makes me think she is quite rigid and might have either. So there is OCD so I'm not diagnosing her. I can't diagnose her. I've never met her. Individuals, but in watching all of this and seeing her behavior, there's also OCD personality traits. A person that is just very concerned with how certain things are. I'm almost positive I talked about that during the sentencing video. And OCD and nothing is, so no diagnosis is an excuse because she was evaluated by multiple mental health professionals and they all just said she's guilty. And so that's where I was thinking OCD personality. The difference between personality type versus OCD, So OCD personality type, there typically aren't going to be medications that maybe anxiety medications might help a little because there's normally underlying anxiety, but that's more of like a personality trait. And obsessive compulsive disorder is normally like frequent hand washing. It might be like people get compulsive thoughts they have compulsive behaviors. OCD personality is more of like this rigid routine, rigid structure. I don't think she's on the autism spectrum. I know sometimes people see defendants that come across a little odd, and they'll sometimes start throwing things like that out. I've never assessed her. I don't know her, so she could, but yeah. And then a lot of like narcissistic type traits. A lot of people throw around those words as we're taking a look at these things too. And then I do like to remind us we are looking at these things on the worst day, but even in looking at all the other trials and looking at all of the other coverage with her, those are the things that pop out to me. All right, let's keep it going.
And it sounds like initially you wanted to find an expert witness to assist you in that defense, correct?
Very much so.
And you went through, you tried 2 different expert witnesses, is that correct?
We hired 2 different ones. We talked to 3 or 4 others, and we talked to other people, but we hired 2.
Right. And is it your testimony you could not find an expert that could assist you in that defense?
Yes, sir, that is my testimony.
Did you discuss with Ms. Vander that you were going to make the argument to the jury that she was guilty of an unintentional, negligent type version of either manslaughter or homicide? Did you ever discuss that with her, that was the strategy?
I can tell you how we discussed it. First-degree murder is an intentional homicide. You didn't intend to do anything, and that's the argument we're going to make to the jury. That's how we discussed it.
Did she ever say, wait a minute, no, I don't want you to do that because I'm not guilty of anything here?
No, Miss Vander, again, she was the client from heaven. She sat and she listened and we talked. She understood, and then she trusted my judgment. At least her conduct indicated she trusted my judgment from that second week on. The only thing, Judge, we ever had a crossword on was about the Michigan-Alabama football games.
So again, she never said, Mr. Johnson, that is not an argument I want to make. I am maintaining my innocence to every single thing that I am innocent, and I absolutely do not want you to concede any sort of guilt in any way, shape, or form.
That is absolutely correct.
Okay, that she did not.
She did not. Not ever.
And you feel, coming from defense background, sometimes defense attorneys have a tendency to they think they know more, they know what's better for the client, right?
Yes, sir.
I know you don't want to do this, but we're going to do it anyway because I want to make sure that we're successful here.
Yes, sir.
Did you do something that she did not want you to do to be successful, or did you do what you had to do in consultation with her about what the strategy was going to be?
The latter. And again, this is a different client than what we normally receive. This is a client who's much more sophisticated about the law and had much better understanding. And our relationship was more co-counsel, or maybe senior counsel myself and junior counsel myself, but more co-counsel than lawyer layman or layperson. She understood the strategy. She conceded that was the strategy that we were going to use at trial. She understood it. She knew I was going to do that. Did she know the exact wording or how it would come out? No, she didn't, because I didn't. But she understood it, and she understood where we were going with. And at no time did she express concerns that I don't want to do it that way. I want to go on and say, I didn't do anything. I wasn't even, whatever her argument would have been. But no, I never asked her.
All right. So it's pretty much going to go like that for the rest of this. The state is going to ask him some more questions. The defense is going to ask him more questions. Let's get to Shanda on the stand. Okay. So
Please remain standing and raise your right hand to be sworn as best you can. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Shanda Vander, Shanda, Vander, space capital ARK.
All right, go ahead, Mr. Ambrose.
Ms. Vander, you heard the, well, first off, your medical condition. Let's just briefly go through that. How's your condition right now?
I'm miserable. I'm lightheaded. My head is just splitting. The back of my neck hurts constantly. It's something that goes along with the thyroid issue, I guess. I've been shaking. This is almost constant now. It started a couple days a week for a few hours at a time, and it's almost constant now.
Would it be your preference to testify at another time?
Absolutely. I feel like garbage.
With that, Your Honor, I would renew my request for an adjournment.
Can I have a sidebar with the attorneys real quick?
The judge, can I have a sidebar? And I didn't pause it, so that's just her face. This is just her face. And so they are going to need another day of testimony. I think she gets pain when things are happening that she doesn't like. And anxiety and stress, it can increase pain. Okay. So anyone with a chronic pain disorder, stress. So she's probably mad listening.
Right. We're back.
She was probably mad listening to Mr. Johnson say all of those things. Okay. I skipped over his catatonic state set part because I did want to just play the social worker. So there is a social worker that is going to testify, and I had not heard of the defense employing social workers which it makes sense that could be a job. I had never heard of it. So her case had over 15 people working on it. So there were multiple attorneys, there were multiple aides, there was a social worker, there were all of these people working on her case. She received a thorough, and that's what the defense, or that's what Mr. Johnson, that's what he testified to. Okay. So that's really cool that a lot of public defenders' offices have social worker based in them. I think that's awesome because a lot of people with because sometimes they might help with resourcing, they might be able to help with different things. And so I think that's cool. And the social worker was present for the trial. So we are going to skip ahead. They are going to adjourn court and bring in this social worker to testify. So let me just get to the beginning of this part. She has a master's degree, worked for a psychiatric facility. Okay, let's go from here.
You've been a master's level social worker.
It'll be 10 in May. Yes.
And were you the social worker assigned for the public defender's office to the case involving Shanda Vander?
For part of it, my understanding is I believe that she was arrested prior to my hire. Once I was hired in September of 2023, that's when I began working on the case.
And could you just describe for the judge, was there a defense team working on Ms. Vander Ark's case?
Yes. In addition to the attorney, Fred Johnson, there was also a second chair attorney, myself. My understanding is that the social worker prior to my hire had met with Ms. Vander Ark, and our office also utilizes a research attorney and an investigator.
So this wasn't just Mr. Johnson and yourself, there was a whole team?
Correct.
Correct?
Yes.
Okay. And did you meet with Mr. Johnson and Ms. Vander Ark together?
Yes.
On this case?
Yes.
How many times would you approximate that happened?
Prior to her trial, I believe twice. During her trial, we met daily.
Did you sit in on the trial?
Yes.
And I apologize, I'm not aware, but where were you at during the trial? Were you near counsel table or were you in the gallery?
Yes, I was near counsel table, not at the table with Fred and Ms. Vander Ark, but in the chairs directly behind.
So you were aware of what was going on during the trial?
Yes.
Were you there every day?
Yes.
So let's talk about the time before trial and those meetings between Mr. Johnson and Ms. Vander Ark. How would you?
And so the state is going to, the state's position, I think, is that the defendant post-trial is now saying, I think the state's theory is because she was convicted, she's upset with her representation. But if she had been found not guilty, of course, she would have been fine. So I think the state is trying to say she's mad with the result, and there was no indication of any issues or problems prior to this. And so, yeah. I did include in this video just how bad Mr. Johnson talked about that video that we have not seen, and I will never play it. And because of how he talked about that video, I won't watch it. There's some things that you have to do to protect your own mental health. And for a lawyer that is a defense attorney that has probably seen a lot of things, for him to say this is the worst video he's ever seen, if that video was ever public, I would not watch it. If she was retried and they played it as part of the trial, I would consider it, but just for my own curiosity, no thanks. There is a such thing as secondary trauma, and if I was going in to watch it, it would be from like a clinic. Like I would have to turn on a certain part of my brain that could be okay seeing something that I know is going to be horrific. Yeah. I try to protect myself from stuff like that if I can. So the video is of, I wonder if it's because the house had cameras, and somebody can correct in the comments if they know exactly what it is. Shanda Vander Ark video not included in, because I think because they watched them, there were some videos that did make it in, but there was a video that they explained and that we have not seen. So I do not know what exactly it's of, and Mr. Johnson did not go into the details. It's minor. I think it's something related to either physical harm or something. I think it's some type of harm towards Timothy. Oh, it was when they found him and then what they did after. Wow. Okay. Thank you, Allison. Chat is the best. And for anyone that gets mad, why don't I, look at everything? Yeah. I like hearing about things, but seeing them is different. So when you see what happened, that it's something about the visual being added. It really can create secondary trauma. So I do try to be very mindful when watching things like that. And sometimes I have to intentionally watch something funny, or I have to reset after watching certain things. So I know for the Perfect Neighbor documentary, I was not prepared for how emotional that one was going to get, and that the body cam was going to not blur out, because I had always seen body cams blurred out. This was not blurred out at all, and that was I didn't have nightmares, because true secondary trauma is where it stays with you and you kind of can't get it out of your head. The video that did cause me secondary trauma was for a little bit, and I was able to move through it, but it took a while. Was the Philando Castile. And it wasn't the video, it was his daughter in the background. That video breaks my heart, and yeah, that video, yeah. And that was the last video that I watched of a police, like a police video like that. After that video, I was like, I will read the article. I will never watch the video again. Yeah. But okay, we can keep this going. This is the social worker talking. So this is the defense social worker that is talking about the relationship between Fred Johnson, who was the trial attorney, and Shanda Vander. Shanda is claiming ineffective assistance of counsel.
Describe Mr. Johnson's interactions with her.
I would, from my perspective, it seemed as though they had a good working relationship. They seemed as though they, communicated freely, both about the case and even just seemed to have an overall good rapport, I would say. They both were big sports fans and they talk about football. From my perspective, recognizing that they likely had meetings without me present as well, it seemed as though they communicated openly with each other.
Did it ever appear as if Mr. Johnson was just going to do things his own way without consulting her or taking her feedback?
Not at all.
Was he receptive to collaboration with her?
Yes.
How was her demeanor in those conversations?
I would say that she seemed very engaged. She was very eager to offer her own thoughts and feedback about kind of case.
As a therapist, I feel like there's something she's trying not to say. She was eager, she was engaged. Some of that sounds like a reframe to me, but it might not be. I could be reading into it a little bit. And remember, these are just my opinions, just based. So this isn't based on any facts. As a mental health professional, I wonder her own personal thoughts. Well, she would never share. So this social worker would never share her personal thoughts about Shanda, and the fact that Shanda is kind of trying to say that Fred didn't do his job when Fred went above and beyond for her. Likely my own personal thoughts, but I think there's some things she's trying to, okay, and she's trying to sound objective. It seemed okay.
Strategy and it's, I guess, demeanor, mood-wise. I mean, she seemed, I guess I'm repeating myself, but the best word I can think of is she seemed very engaged.
Now, you did mention, though, that she had thoughts on strategy. Were you present for discussions on trial strategy?
Very minimally.
Okay. What was your minimal involvement on that? Or at least what did you observe, if anything?
I want to make sure, I guess, that I recollect as clearly as possible, so excuse my pause. The conversations that I remember involved talking about obtaining an expert evaluation, a psychologist, to evaluate Ms. Vander, and we all agreed that that was a good next step. So that's the primary discussion that I recall as it pertains to strategy.
Okay, so obtaining experts and seeing what their opinions would be.
Yes.
How generally was Mr. Johnson's tone with her?
He's one of the friendliest, warmest individuals you probably will ever meet.
And he continued that in his client meetings with her?
Yes.
Did Ms. Vander ever complain to you about Mr. Johnson?
No.
Did you also assist in this case with Mr. Johnson when the defendant was not present?
Yes.
Okay, how so?
He and I would...
Yeah, I need to speed her up just a little bit. We're going to try 1.25. All right, we're going to try 1.25. This is sped up, 1.25 speed.
primarily discuss any updates.
Oopsie, sorry.
If we were waiting for the psychologist to report back to us about his findings, or I guess that's the primary thing. I can't recall anything else specific.
Did you assist in sort of facilitating the interviews with the expert witnesses?
Yes.
Okay. And specifically, did you assist in, or did you participate in the interview with Dr. King?
Yes.
When I say that, I don't mean your interview with Dr. King, I mean the
Correct.
defendant's, correct?
Correct.
Okay. And ultimately, at the end of that interview, was a preliminary assessment given by Dr. King?
Yes. I
What was
was in, I guess to clarify, I am not the person who initially contacted Dr. King to arrange the assessment. I believe that was done by the social worker that was employed before me. When I was hired, that is when I kind of took over that role. I did participate in the interview with Dr. King, and after Ms. Vander had ended her portion of the call, Dr. King and I were still on the call together, as well as I think he had a research assistant that was present. And I am not quoting by any means his exact words, but his initial or preliminary assessment was that he did not feel that Ms. Vander was incompetent or severely mentally ill, and felt that he could not provide a good defense for our office.
Was Mr. Johnson on the call at the same time as you, or was that just
He
you?
was not.
Okay. So you obtained that information. What do you do with it?
I told Mr. Johnson about it.
And then, to your knowledge, and only answer if you know, did Mr. Johnson speak to Dr. King as well?
I don't know for sure. I know that Dr. King sent us a report. I don't know if they had a separate conversation.
But he wasn't a part.
And then I just want to, so Sarah Boone was outright demanding. I don't know that Shanda was demanding, because I think her team was doing what she wanted until trial happened. And I skipped over the part where Mr. Johnson said his trial strategy changed when Paul mentioned texting her the picture of Timothy. Like, I think there was something that Paul said that made it so that she had to know that she had to know that this was bad, and just how bad things were, and that she chose to not act. Like that's when he was like, "Ooh, can we maybe get manslaughter or second degree?" Like that's his goal, was to not get first degree, and they did. Okay, let's keep it going.
To the conversation with you and Dr. King.
Correct.
So, Ms. Kentucky, in your professional capacity, do you sort of have to assess whether or not individuals are alert to person, place, and time?
Yes.
Okay. And do you just sort of naturally start to do that when you're communicating with defendants at certain points?
Yes, definitely. I mean, most times that I meet with a client, I have my own kind of internal process as far as the things that I'm looking for, assessing, as you said, to kind of a mini mental status exam of sorts. So a person being oriented, as you said, is a component of that, whether or not they're having thoughts of harming themselves, other people, whether or not their thoughts are logical, coherent, things like that.
So did you just sort of relate a whole checklist, or is that just a brief snapshot?
That's just a brief snapshot.
So could you just walk us through what your general checklist would be when you're communicating with a defendant?
Right. And somebody mentioned something about stealing toys, and what could have been happening is maybe they were restricting things from him, and maybe he was just taking them back. Like, I think that could have been what was happening. I don't think that she had appropriate expectations for Timothy, and it's a red flag that she was not supposed to have unsupervised contact. There was a founded CPS case in a different state, and the father had full custody. The state never went after the father, because I think it would be like, but they never went after the father. I don't even think he came for the trial. I think his wife did. I think the stepmother came. But yeah. So I don't believe in stealing food, and they are starving him. So I think all children should have access to something. So at 9 p.m., if my child is like, "I'm hungry, mommy, I'm hungry," I would be like, "Okay, you can have some fruit." But that would be his, or you can have some crackers. I would give him food. If right before dinner my son was like, "I'm starving, I can't wait 30 minutes," you can have some fruit. Like, there would be something. um Being denied food, it can access the amygdala, that survival part of the brain. Now, there have been other times when we're at a restaurant, and so that's where, for Thanksgiving, this happened. So our lunch reservation for Thanksgiving was at 1 p.m. and my son ate breakfast, I think at 8 or 9 a.m. And so around 10 or 11, I think it was 11, around 11, I made sure he had a snack. So hungry, angry, lonely, tired, halt. Hungry, angry, lonely, tired. Those are things that I monitor, because it can really cause issues. Thank you for the $9.99. while Vander Ark's lawyer may not have fully explained things, given her extensive legal knowledge, I think he represented her fairly, given the overwhelming evidence of her guilt. I agree. And that's where the state wants to introduce the fact that one of the jurors that kind of, it took them more time to get on board with guilty of first degree. It was his defense strategy that kind of had that juror on the fence of, is it one of the lesser crimes? And so, yeah. It does remind me of Ruby Frankie. And so when people get weird about food, I'm not a fan of that. I am not a fan of that. Yes. Hey, hungry, angry, lonely, tired. It works for adults too. It's not just for children. If Dr. Barry's hungry. So I warn my husband, like if let's say we're out and I haven't eaten in a while, I kind of say, hey, you have 30 minutes to an hour to feed me before I'll tell you what I really say. So I never bite people. Well, I don't bite him hard. I don't like, it's like, I don't, oh, okay. I'm not under oath. I don't bite people. That's a lie. I don't bite. I do. It's a playful. Okay. We're just going to keep it going. I'm gonna press play.
Sure. I would note any kind of observable things. So like, are they disheveled? Are they, as best they can, given the circumstances of being in jail, kind of tending to their hygiene? Is their speech pressured? Is it unusually slow? Sometimes that can be an indicator of like a thought disorder, if they're experiencing what we call thought blocking. Sometimes if people are doing what a kind of a clinical term, being like loose associations, so making connections with things that you or I would not make connections with, or hearing messages from, that you or I are not hearing, so kind of responding to internal stimuli. And what I mean by that is, do they appear to be hearing voices? Those are, the primary things that I'm looking for.
So turning to the trial in this case,
Mm-hmm.
was Ms. Vander, I know I'm pointing over here where my table is, but Ms. Vander was seated over here, correct?
Yes.
And so were you?
Yes.
And you were able to personally observe Ms. Vander Ark throughout the trial, correct?
Yes.
So let's start with the first couple of days.
Okay.
Did she have any concerning behaviors on your sort of internal checklist, for lack of a better term, during the first couple days of trial?
No, I would say similar to prior meetings with Ms. Vander Ark and Mr. Johnson, she seemed very engaged. She was frequently taking notes. She would lean over, and communicate with Brad. I'm not privy to what they were discussing because those were often in whispers, but she seemed alert and oriented in all aspects.
Did you converse with her at all during the first few days of the trial?
Yes.
Was there anything remarkable about her conversation that alerted you to a mental impairment?
No.
Now, I do want to jump into the time frame after she testified.
Okay.
Were you present for her testimony?
Yes.
Okay. Did you view, and that was a Thursday, do you recall that it was a Thursday?
Yes.
Okay. Do you know, after court concluded for the day, did you speak to Ms. Vander Ark after the proceedings ended?
I don't remember if it was, I know I did on Friday. I don't know if I did on Thursday after.
So Shanda is trying to say that she was so distraught and she was in such a state that, and I guess, so it is going to come in that a deputy drafted that she was refusing to return to court. So a deputy drafted something and that was given to her lawyer. Her lawyer, she signed it because and everybody's going to say she refused to go back to court. Shanda's trying to say she was unable, she was medically not able to return to court. And that's where she's like, okay. I think she has been on the harm watch before. And, but I don't think that has anything to do with this, but that some aspects of that did come up with the deputies. I'm going to skip over that part. The full hearing is in the description if you want to watch it without all of my lovely pauses.
The after court proceedings finished.
So let's jump to Friday.
Okay.
Did you respond to the jail?
Yes.
And you observed Ms. Vander Ark in the holding cell?
Yes.
Could you tell the court what you saw?
Yes, I was on my way to court when Mr. Johnson contacted me and said that he needed my assistance down in the jail because Ms. Vander Ark was having a difficult time. So when I arrived, he was already in the holding cell with her and she was very distressed. She did not want to go upstairs, and repeatedly said that she couldn't do it. And Mr. Johnson and I repeatedly tried, I mean, kind of, I guess, every way we could think of to try to provide the support that she would need to go upstairs. So I don't know how much detail you want me to.
So let's unravel this a little bit. So Mr. Johnson was actively attempting to get her to come to court.
Yes.
And you were assisting him on that?
Yes.
And it was your testimony that she did not want to come up to court. Is that correct?
Correct.
Did she say it in those words that she didn't?
Okay. So I'm hearing this for the second time. Okay. And the state is emphasizing that she did not want to come up to the court. And the state called her. The defense did not call her. So the defense was able to call witnesses. And I keep saying defense, but that's Shanda's side. So she's appealing her conviction. And I just want to say, like, our legal system, it has checks and balances for a reason. And it does often feel like offenders have a ton of rights. But if I was ever on trial, I would want all of those rights. So I try to be mindful of that. So if her attorney did something legally wrong, then that would be a reason, like, okay, you get to you get a new trial if your attorney did something wrong. Alec Murdaugh, I don't know if he's going to get a new trial because of Courtroom Becky. So the court reporter Becky, she was out here doing the most, trying to become famous. In my opinion, I guess she wrote the book and possibly like leaked photos that shouldn't have been leaked. And there are all of these allegations. I don't know when her trial starts, but so if people's rights are violated, that should be it. I haven't heard that anything has been violated, but I'm not an attorney. This is going to be up to the judge to decide, and they're going to have another day of hearings. So next week, I think, I don't know if they've scheduled it yet, but the judge said he wanted to do it as quickly as possible. And so the judge is going to make a decision, and then it's likely going to be appealed to the next level. So if she's not successful here, she's going to use her appeals, because she has appeals. She has time. I think she has a life sentence. Like, she has nothing but time. And yes. All right, let's keep.
Want to come?
I don't know. I'm sorry.
Was she experiencing any psychosis?
She did not appear to be experiencing psychosis. I would say that she appeared to be very anxious.
How was her speech?
It was, I would say, pressured, but like going back to those pieces that I touched on earlier, although pressured, it was still logical. It was relevant to the topic at hand. She wasn't making those loose associations. So I would say again that pressured speech would be consistent with anxiety.
Was she oriented?
Yes.
Okay, meaning she knew who she was and where she was at.
Absolutely.
And from her conversations or her statements, she knew what was upstairs, which was a trial.
Correct.
And she chose to not go upstairs. That's what I keep hearing in this, and that she wasn't in some catatonic state. Because her attorney, who isn't, like, he's not a psychologist, he's not a medical expert, and the social worker who has an understand. So catatonic would be non-responsive at all. Catatonic looks very different. I have seen individuals in a catatonic, not often, but I've done work in mental health hospitals and residential hospitals. Yeah, so she was not catatonic.
Did she appear to understand sort of what would occur at the trial?
Yes. Yes.
So she understood that there'd be additional witnesses.
Correct.
And sort of the court process.
Yes.
Okay. So she wasn't delusional.
No.
She wasn't catatonic.
No.
And when I say catatonic, what do you take catatonic to mean?
The most kind of classic catatonia presentation is one that is withdrawn. So in that particular presentation, oftentimes people are not responsive to communication. They might not even be responsive to touch or painful stimuli. They often are not eating, they're not drinking, they are kind of in a stupor.
Did you see any of those signs with Ms. Vander on that day?
No.
Were you present for any discussions about Ms. Vander waiving her right to appear at court?
Yes.
Could you tell the court what those discussions were?
When we were in the holding cell and there was a great deal of back and forth, I would say. At times, Mr. Johnson would leave to, I believe, go upstairs and communicate with those who were up here, whether in chambers, about the status of Ms. Vander, that she was having a difficult time. He would return.
So they did delay court for 2 hours, I believe. So on this day that she was having difficulty, she was having supposedly some type of, so a panic attack normally lasts for maybe at most, like it's normally it's normally short. Panic attacks, like a true feel like you're having a heart attack, those are 10 minutes or less. I think she knew this case was going wrong, like it wasn't going the way she wanted it to go, and I don't think she wanted to go back into the courtroom. I think she didn't want to go. 60 minutes max, like, you don't have a panic attack for 2 hours typically. Now, all the stress of what she had done, maybe, I don't, but she didn't seem fazed by any of that. Her reaction to seeing the photo, because that photo had been displayed before and she didn't have that reaction. She had that reaction when it was placed in front of her, but she saw him in real life and didn't feed him. And the state, I think, I don't know if that was part of their closing, but if I was a lawyer, that would have been part of my closing. Like, she's over here reacting to a picture. That was her son. She saw him like that and she didn't do anything. And so if for some reason, so that's where we all have to breathe. If for some reason she did get a new trial, she would be convicted again. But in her mind, it's that Sarah Boone mentality. I think she thinks she can convince a jury that she's not guilty. She probably didn't like how people saw Paul as a victim. So they might have a different strategy with Paul next time. I don't know. I don't know if they would have a different strategy, because to me, her co-defendant, they weren't tried together. And he accepted a plea deal with the state. It didn't include any specific amount of time, but because he still got quite a bit of time, as he should have. I did a video on Paul. You can, I have those videos linked down below too. When I saw Paul's testimony initially, I hadn't watched his police video. So Paul was her adult son that was the enforcer. He's the one that did all the things that she told him to do. And there are, like, when you have an authority figure telling you to do things, sometimes people, normal, healthy, good people, will sometimes follow authority out of, like, it's one of those, so trigger warnings for, like, but it's one of those, like, Nazi Germany things of, like, how do so many people go against this thing? But Paul had a history of harm. It's my understanding, based on all the chats and everything. He had a history of harm, and likely from his own abuse, but still, that doesn't justify anything. But yeah. So I don't know that she wants attention. And so normally when I think of histrionic, I think of, like, Amber Heard, and maybe, I don't know, like, I think of a very different presentation. She doesn't come off, because histrionic sometimes has this, like, sexualized, like, I don't know, and this need for attention. I get more narcissism. I get other things. OCD personality. I've never met her. I can't diagnose her. These are just general comments based on publicly available information. Okay, we're almost done with this part.
And eventually, it was my understanding that, since it became apparent she was not going to come upstairs to court, that she could waive that participation. And so that was explained to her. I could not tell you, I guess, the exact language that Fred used. Mr. Johnson. Yes.
But there was discussion of that.
Yes.
And were you aware that she filled out an affidavit or a signed document of some sort regarding her waiving her presence in court?
I guess I don't remember that exactly, no.
But you do specifically remember Mr. Johnson explaining that to her?
Yes.
What was her response?
That is what she wanted to do.
Okay. Did she vacillate at all on that, or was she clear?
She was clear.
Did she give any further commentary on it?
If anything, I would say that she seemed appreciative because she very much did not want to go upstairs. So she felt, or it appeared as though she felt relieved by that option.
All right. So they take a break. And then, okay, so the defense side must not have asked her very many questions. Okay. Oh, y'all. So there's going to be a part 2 because Shanda likely wants to say something, but I think it's more to protect her ego and her image and to correct all the things that she thinks was said wrong. Because I personally feel, I don't know that it's true, I think she's going to change how she viewed her conversations with Fred. And I hope Fred took notes. Do you know what I mean? Like, because she's over here shaking her head like, I didn't do that. I didn't say that. I didn't agree to that. Ugh. And I don't know if lawyers take those kinds of notes. So for mental health, we do take notes that kind of protect us. If a client does make a claim, my note is what I wrote down is what matters most. It's not what I say. Like what I wrote down is what matters most. So the amazing Dr. Curry said features of borderline and histrionic. That's what she said for Amber Heard, based on her evaluation. That trial is how I kind of got into true crime. So expert testimony in true crime. I love Dr. Curry's testimony, and it was actually one of my clients that recommended I check out Law Nerds, that I check out Emily D. Baker's channel. And I like that was my indoctrination. Like I was like, oh wow. And that's when my YouTube channel took a bit of a shift, looking more into trials and all of that. When I covered that trial, I didn't know how to use StreamYard. So I was using Riverside. I was using some other streaming platforms. StreamYard makes it easy. Not sponsored. I pay for my entire subscription, but their prices went up. The company was, I don't know, they made changes. I don't mind it. I'm not doing the vertical streaming. So, and I might do a poll of, do people like vertical streaming when it can show up in the phone? It shows up different. I don't know. Some people like, so I might do a poll. It splits the stream where it makes it show up twice. And I don't know if I like that. So yeah. That might have to be a video that I do. That would definitely be a very good. I've never done that. I've never watched Dr. Curry's testimony for you all. Yeah, I don't like the vertical streaming. So yeah, I don't think I'm going to do it. So YouTube algorithm, I think, likes it because it gets people that are on the shorts tab, because I think it shows up. It lets you be discoverable in shorts, but I don't know that my content works well there. So I think I'm gonna keep saying no to vertical and just keep streaming this way. I'm just gonna stick to that. Yeah. I might go on ahead and private the I probably am gonna go on ahead and private the vertical streams that are available. I think I'm gonna go on ahead and unlist those. Thank y'all. The chat is amazing. Big contrast to Dr. Hughes. Yes, yes. Yes, yes, yes. I think Mr. Johnson, Shanda's trial lawyer, I think he did a phenomenal job. And I sometimes say her name wrong. It's either Shanda or Shanda. I think it's Shanda. I think it's Shanda Vander. She doesn't like it when people say Shanda, because I think on some streams I might have said it wrong. And I try to keep people's names right, but when criminals want their name said a certain way, sometimes I don't know. I can be a little special. So yeah. Yeah, yeah. So I think I am gonna private those vertical streams. I hope you all enjoy the rest of your weekend. Somebody mentioned at the beginning of the stream, did I say I was going to take Saturday this weekend off? No, I told y'all I was taking Friday off. So I did. I enjoyed Friday. My Christmas tree is up. So on Friday, my son said he was going to help, and then he was no help. He ended up watching Dragon Ball Z with dad down in the basement. And so he was able to come up and see Christmas cheer. So I did that on Friday. I am all caught up with my notes. And if you are a therapist, you understand the like applause. Okay, I'm going to play with my roadcaster to see where the applause is. Oh, that's not it. That's not it. I can't have toys. So my notes are done. My notes are never done. Never ever done. It's mostly because I only saw clients Monday through Wednesday, and I was able to catch up on all of my notes from Thursday to Friday. So my notes are totally done, but then I see like 8 people on Monday. So I'll just fall behind again, and I'll catch up on documentation on, I'm normally not more than like a week or 2 weeks behind because I don't do my billing until, of course, because legally you can't submit the billing until the note is done. So I try to do it within a week. If insurance is watching, it's within 1 day. Whatever the requirement is, that's what I do. I so appreciate you all. Um, I did an update, hopefully, so check it again. You might have to refresh the stream, and then the video description should be there because I just pressed save. So if you refresh the video, because I think when I started, I didn't have it up, or let me see if I have to do it again. Ah, ooh, and y'all got no ads because I'm about to turn ads on. I think I forgot to do that. I appreciate you all, and I will see you all next time. I hope y'all have a good one. Bye.